I think that the Microsoft case touched off a global discussion of how to deal with FRAND patents. I think we're still in that evolutionary process that we don't know the final answer. And I look at cases like unwired patent, Justice Burse out of England, as offering kind of his view of how we should proceed. The fact that we're having this discussion, to me, is indicative of the fact that we're in the digital age. The importance of standards when you have cellular telephones extensively used all around the country. And in a lot of lesser developed countries, it's the exclusive telephone system that's used. Means that you can't simply base this any longer on the US market and on the European market. And right now, I think there are differences between the European market and the US market, particularly after the IEEE steps right out. ETSI, E-T-S-I, steps right out and says, this is how we're going to do this. So I think the legacy is that we need to develop a more common language. As I've spoken around the world on this case, I see a lot of differences. There are a lot of differences in Asia than there are in Europe, and there are a lot of differences from Europe to the United States. But I think in terms of starting that discussion, and one of the cases that's cited most often in the sort of seminal opinion in whatever country you're in, Apple v. Samsung in Japan, as an example, starts by talking about what we did in Microsoft. So I think it has a long-standing legacy. I often think that Georgia-Pacific is the most commonly cited district court decision. I think the Federal Circuit is going to get cited more often than Microsoft, but Microsoft has the advantage of having opened that discussion in the first place.